Now let's see how Bill is doing in preparing his case.
The hearing is a week away now, and I'm starting to get nervous about what to do to prepare. I'm wondering what I need to do to prove my case.
Bill is right to start preparing his case well ahead of time. He will need to prove that the plumber's work was defective, that it caused damage to his flooring and had to be redone. It will be up to Bill to produce the necessary evidence. To prepare for trial, he should keep copies of all documents that he receives regarding the case and develop an outline of the evidence he will introduce and questions that he will ask any witnesses. He should also organize any physical evidence that he wishes to present. There are several types of evidence that he can present. One type of evidence is his own testimony or testimony from other witnesses. If you are not sure whether one of your witnesses is willing to appear in court, you can obtain a subpoena from the court that will require them to appear. You can talk to the court clerk about how to do this. Your witnesses must have personal knowledge of what they are testifying about. If they don't, their testimony may be hearsay. Hearsay is secondhand evidence, what someone other than a witness saw or heard and is not allowed. For example, Bill cannot testify as to what the second plumber told him about the quality of Jim's work. The second plumber himself must testify. You should also be aware that when you ask your own witness questions, you may not ask leading questions. These are questions that suggest the answer, such as, "You thought he did a shoddy job, didn't you?" Instead, you must ask your own witnesses open-ended questions, such as, "Could you tell us whether or not you had a chance to look at the plumbing work that Jim performed? Could you tell us whether or not you saw any problems with the work that Jim did?" However, you may ask leading questions of the other side's witnesses when you are allowed to cross-examine them. That is, ask them questions about their testimony. Okay, now we have talked generally about testimony. Let's talk a little about a special kind of testimony, expert witnesses. Here, Bill will want to call the second plumber, Paul Groff, to testify as to the quality of Jim Raffro's work. Because this testimony will require Paul to offer an opinion to the judge, he will have to be qualified as an expert witness. That means that Bill will need to show that Paul has some unique knowledge due to education or expertise that enables him to give an opinion to the court as to the quality of the previous work. Therefore, Bill should start by asking him about his training, experience, and whether he has any certification to establish that he is an expert in the field of plumbing. Then, Bill should ask how he arrived at the opinion that the previous work was defective. If the judge is satisfied that Paul qualifies as an expert witness, she will allow him to offer his opinion as to the quality of Jim's work and whether it was the cause of the resulting damage. Another type of evidence that Bill may wish to show in court is called demonstrative evidence. This type of evidence includes photographs, diagrams, or physical evidence that demonstrates a point being made in the case. For example, Bill might want to bring a piece of the ruined flooring and a photograph of the flooded kitchen. It is important to remember that if you bring a photograph, either you must have taken it or a witness must testify that it is a fair and accurate depiction of the condition that existed. The final type of evidence that Bill may wish to bring to court is documentary evidence. This means documents such as bills, receipts, correspondence, appraisals, pay stubs, or a contract that will help to prove his case. When using documentary evidence, you should bring the original document, if at all possible, along with 3 additional copies. You must also bring a witness to testify as to the authenticity of the document, such as the person who wrote the letter or prepared the bill. However, there is one important exception to this requirement. In the Justice of the Peace Court, business records such as bills, estimates, receipts, or statements of account, which appear to have been made in the regular course of business, may be admitted into evidence without authentication by a witness if the judge is satisfied that the document is reliable. In this case, Bill should bring copies of his bill from the other plumber, as well as the bill for the new carpet and its installation. In sum, in preparing your case, you should do the following. Keep copies of everything you receive or send regarding the case. Think about what you are asking the court to do and why. Consider and obtain evidence you need to help the judge decide. If you are not sure that a witness will come to court, get a subpoena. Create an outline of your case, including each fact that you want to prove and what evidence you will use to prove it. Create a list of questions for your witnesses and questions that you may want to ask the other side's witnesses. write a closing statement summarizing your evidence and what you are seeking or your defense to what is being sought against you. Keep all copies, evidence, and notes organized so that you can find what you need quickly and easily in court. The same basic rules apply for Maureen's custody modification case in family court as apply for Bill's case in the Justice of the Peace Court. Of course, given the different nature of the case, Maureen will need to present different evidence, but she should consider the same category of evidence: witnesses, demonstrative evidence, and documentary evidence. She will need to find evidence to support the change in custody that she is seeking, particularly that her ex-husband has been leaving the children unattended. Factors such as how the proposed change would benefit the children with regard to the attention paid by one parent over another, schoolwork, activities, etc., will need to be supported by testimony and/or other evidence. She may also ask the court to interview the children. As with Bill, Maureen should make an outline of her case, including questions and a closing statement, so that she is prepared for her day in court.